It's a small subset of the forensic mental health population, but it is an important subset of individuals because many people who are developmentally disabled who had been in special education, they didn't necessarily have civics class. They don't necessarily have a lot of experience with the criminal justice system. Mm-hmm. So they often need a lot of basic education about the court process that persons who did not have special education, persons who have average or above average intelligence would know about and maybe would have had experience with. What we do in those situations is we either on an inpatient or an outpatient basis, either at the Eleanor Slater Hospital or out in the community with a provider like Riverwood or a mental health center, we try to identify a trainer who agrees to speak with the individual and talk to them about the competency process. Mm-hmm. And we have what is called module-based training. There are certain modules that the person goes through to learn more about the court system. And again, we give it the time that the person needs to see what they can learn. And ultimately, if they can be restored to competency by going through this specialized process, we recommend them to the court as competent. If they cannot be restored to competency after a period of time, we recommend them to the court as being incompetent and what is called non-restorable. And we basically say that we don't think that the person could ever fairly go in front of a judge or a court and have a resolution of their charges. It also has been a very nice way of connecting people with outside agencies and providing people with care and treatment during the court proceedings, and for us to be able to see how they do, again with this idea that if they don't do well, if there is a problem in the community, then the person can come back very quickly to the forensic unit for readmission.
Oh, okay.
Yes, and it is different, as you were saying, from the forensic competency restoration groups that we hold in the hospital. In the hospital, where the vast majority of the men that are in the unit, the vast majority of them are of normal intelligence or above average intelligence, and so we have competency discussions with them in large groups, and they don't really require a lot of one-on-one time. But if a person is developmentally disabled, they often will need that additional assistance.
Oh, okay. Now, a person who has a primary diagnosis of a developmental disability, as well as someone who might have a co-occurring mental health issue, both of those folks may end up at the forensic unit for evaluation, correct?
Well, they will often end up on the forensic unit after their evaluation has occurred, either at the ACI or elsewhere.
Okay.
Yes.
So evaluations can they can happen in the community.
Yes.
They can happen at the ACI.
Yes.
Okay.
They can happen in our outpatient offices at the forensic service.
Oh, okay. All right, great. Now the second I.
Yes.
Insanity. What I keep hearing is NGRI, which
Correct.
is not guilty due to reason of insanity.
Correct.
Can you explain how that process works as it compares with competency?
Sure. The competency standard is a national standard, if you will, because the United States Supreme Court had a decision back in the 1960s that defined legally what competency to stand trial is. The insanity, the definition of insanity has had a more storied past than the competency paradigm. And there are various definitions of what insanity is in all the jurisdictions across the country. And our definition of insanity in Rhode Island is that a person is thought to be insane or not guilty of the commission of a crime because of their mental illness if they either didn't have the ability to appreciate right from wrong, or if they were unable to control their actions at the time because of their mental illness. So one of the first things you need to know about insanity is that the definition of it varies from jurisdiction to jurisdiction, so
okay.
It's unlike competency. The other thing that when people confuse this process, people will often think that a person that's raising an insanity defense is beating the system. The general public, I will often hear comments where people think that the insanity defense is widely used that it's wildly successful and that people just get off the hook, if you will. Nothing could be further from the case. The insanity defense is rarely used. When it is used, it is not successful over 90% of the time because it's very hard to prove that a person was either not able to appreciate the difference between right and wrong or unable to control their actions because of their mental illness. We have about 1 or 2 cases, new cases of insanity findings per year. And basically, as you know, I'm not a lawyer, but basically the law says that to be found guilty, you have to have done 2 things. You have had to committed a guilty act, and you must have had a guilty mind at the time. And if you don't have the guilty mind, you may have committed a killing, let's say, or you may have committed some other criminal act. But as long as you did not actually have a guilty mind at the time, then you are legally insane. Now, the term insanity these days is really only used in the law. It's not a psychiatric term, and it's really only a narrow legal definition. So when someone is found insane or not guilty by reason of insanity, it's a strict definition, and again, it's used very rarely.
Now, that's also the subgroup that may end up staying at the forensic unit for many years.
Yes. One of the things that the law in Rhode Island says is that if you are found insane, you are held under the custody of the director of the Department of Mental Health until you no longer are thought to pose a risk to society. Well, that's a pretty high standard to basically say that you hold someone until they don't pose a risk anymore. So since that standard is so high, generally speaking, after we do a risk assessment, because the next thing that happens when you're found insane by a judge is you come to our unit, and then I or someone that I work with will conduct a risk assessment. It's very unusual that we would say that no one is completely risk-free. So what that means is the person then is held, typically on the forensic unit to start with, and is held for many, many years. This makes this defense actually rather unattractive to defense attorneys because they know that if an individual is found insane in Rhode Island, the amount of time that their liberty may be deprived could be longer than if they had just served time by going to jail and pleading guilty and copping out a plea or something like that. So for that reason, the level of intensity of services that somebody gets as a result of being found insane and the idea that these individuals are watched very closely and monitored very closely where no matter where they are in the system, all of this means that the insanity defense is really only used for the most serious crimes in Rhode Island, like murder or attempted murder, rape or attempted rape. Those are generally the original charges that will prompt an insanity plea.
Okay, all right. You know, you learn something every day. Dr.
Absolutely.
That's
I
great.
sure do.
Now, the last I has to do with the inmate who's having problems at the ACI and is remanded back to the forensic unit for treatment.
Yes.
Now, what is the percentage of folks that are at the forensic unit that might fit that criteria?
Generally, we have about 4 or 5 of those individuals at a time that are in the hospital having been transferred from the prison for services. And again, just to put all of this into the big picture again, the incompetents are pre-trial. That is, they haven't yet gone to trial. The insanes are people that are post-trial, but they were found not guilty by reason of insanity at the trial. So the other group, the inmates, are the post-trial individuals who were found guilty at the time. They are serving time. They have been found to have committed a criminal offense against the people of the state, and so they are doing their time. It's important for people to realize that the ACI, the Department of Corrections, has a mental health has the ability to provide mental health services at the ACI. So there are psychiatrists, psychologists, social workers, and therapists who work with these individuals during their incarceration. But it is also true that just like in the community, from time to time the community-based treatment is something that is not enough and the person needs to go into the hospital.
Right.
The same occurs within the ACI. Sometimes
You're
the
kind of the hospital for the ACI then at that point.
That's correct. We're the hospital for the ACI.
Okay.
And so that person then gets admitted to the forensic unit.
Okay. Well, we have run out of time, Dr. Wall. I really appreciate you coming today, and I appreciate everyone watching Minds That Matter. Thank you very much, and thank you for being part of the show today.
Thank you.